young boss, got me feeling like the rock. They can never match it, they can never stop.
Hey there, this is attorney Sarah Holmes of Holmes Business Law PC. Today we are giving you a new update as to the American Riviera Orchard trademark applications pending that were filed by Meghan Markle's company. So a really interesting update has occurred this month, which is that a letter of protest has been filed by the big company Harry and David, stating that they also have a mark called Royal Riviera for goods similar to those which are found in the trademark applications for American Riviera Orchard, and therefore they think that this could potentially be confusing. Now, this is really interesting and actually a pretty complicated issue for trademark purposes, and I'll tell you why. So we have a prior video, right, where we broke down all of the trademark applications submitted by American Riviera Orchard. Then we had a second video where after USPTO, the examining attorney, looked at the applications and submitted some office actions, which are basically initial refusals. But all of the issues first raised by USPTO are generally ones that could be easily overcome. We talked about how some of the goods and services might need to be refined. Someone needed to actually sign a declaration and sign off on the application. And just these really sort of nitty nuances that would not be difficult for a reasonably good trademark attorney to fix for them, right? And interestingly, what we noted was not raised by USPTO was a likelihood of confusion with any existing marks. So when USPTO themselves did a search of their database to determine whether any confusing marks were out there, they did not raise that they felt Royal Riviera would be confusing. So what's happened though is that Harry and David finds it confusing, and they submitted a letter of protest stating, hey, why didn't you catch this when you did the search? We think it's confusing and we want to tell you now so that you could potentially now also issue an office action on that issue as well. So if you look at the public information now in the trademark file for the American Riviera Orchard filings, you'll see now it's noted that a letter of protest was filed, and a senior trademark attorney is now sent a memo to the examining attorney on the ARO marks telling them, hey, this issue has been raised. You need to go back now and determine whether you think this is an issue and have another office action sent, or whether it's not, in which case, once all those prior issues could be resolved, the trademark applications would go to publication, meaning that would open up a 30-day period where anyone in the world that felt they had a conflicting mark with any of them would have an opportunity to file an opposition. So we haven't gotten to that point yet, but I would expect that if Harry and David is going through the hassle, not much of a hassle, it's pretty easy, to file a letter of protest, that once that 30-day period opens for opposition, they're going to be filing an opposition. So this makes for some really interesting mechanics of how the whole trademark process works. It's going to be interesting to see now what USPTO and the examining attorney does in these applications, whether now they go back and say, oh yes, Royal Riviera is confusing and we are going to issue another office action, or whether they don't and now Harry and David has to wait until the marks go to publication to file an official opposition. Now, what's really another interesting point is if you look in the database and you see what Harry and David has registered for Royal Riviera, they have some marks that are very old. In fact, they have one for Royal Riviera dating back to the 1930s for pears, right? What they didn't do, it looks like, is file a lot more marks for many other types of goods and services over the years. So some of the applications they've filed are extremely recent. They're from September of 2024 for things like some more of the preserves or kitchen linens, things of that nature. And that is the stuff that is certainly more like the types of goods and services that Markle wants to sell. The difference though is that Harry and David is stating that they used these things much earlier. They're stating that back in 2019, 2021, 2018, in one of the cases, they used these things first. Markle beat them to the filing, which maybe would work in her favor But Harry and David says, no, we use these first. We have common law trademark rights, meaning we've been using all this time. They just didn't have formal applications for it. So it's kind of gearing up to be a big battle. And trademark litigation can be some of the most expensive litigation that parties engage in. So it's going to be really interesting to see how much money ARO wants to put behind these battles, if they're going to change the name. Quite honestly, I can't imagine they're going to change the name at this point. So what normally happens is the parties reach some sort of settlement agreement. Maybe they agree on separate markets that they will serve so it doesn't become confusing. They might agree to split up certain types of goods or services so it's not confusing to consumers. And they might end up settling these issues in the end privately through a contract or agreement that we wouldn't really know what the contents are. But we will be able to tell from the disposition of all the various trademark applications what's going to go forward as far as formal trademark protection that's granted to either of the sides. So super interesting stuff to watch. Keep an eye out, and we will put up screenshots and links to the various applications so you can also get a view of what's going on. Thanks.
So the enemies, I'm taking them apart. I'm a young boss, got me feeling like a rock. They can never match it, they can never stop. Cause I've been really giving everything that I got.